Thank you, Chair. Where we concluded matters yesterday was at the point at which BNP had been provided with a letter of award in relation to the sourcing of funds. I'd like to start there this morning again, if we may. Ms. Stimpel, you'll find that in Bundle B, because that's the one we're now working in for today's evidence, and it appears at page 490, which is under tab 46. Ms. Stimpel, you'll recall that we had looked at this towards the end of yesterday. It is the letter of award for the sourcing of funds for South African Airways that is dated the 25th of May 2016. I'd like us just for a moment to turn over the page to look at the date on which the acceptance and agreement by BNP Capital is filled in there. That's at page 491. Ms. Stimpel, can you just indicate to us there, you see after the signature of the Acting Chief Procurement Officer, there's a section that says, accepted and agreed to by BNP Capital Pty Limited. What appears thereafter?
It says by who warrants that he or she is duly authorized, and then the full names of Mr. Polisani Daniel Matlangu, his designation being director, and it is dated the 3rd of June 2016.
Thank you. There is some significance I'd like to suggest relating to that date, which is the 3rd of June 2016, because the next point that you make in your affidavit from page 19 at paragraph 108 is that on the same day that the letter of award is sent to BNP, which is, again, just to remind ourselves, the 25th of May 2016, there is a letter from BNP back to SAA asking about a cancellation fee, and we're going to go through that in some detail now. But just to be clear, Ms. Stimpel, were you aware of this correspondence at the time?
Not at all, Chair.
And so how did you come to learn of these documents?
The first time I got to know of these particular documents, there was the one where there was the letter of acceptance in my own personal case when SAA sent documents, but the full detail that I have now I got from the Zondo investigators.
Thank you. If we can then go to that letter that comes back.
Yes, I'm sorry, Ms. Hoffmeyer. You referred us to 490 and then 491.
Correct.
My attention was still on 491 when you referred, I think, to another document.
Indeed. Apologies, Chair.
Before you go to that other document, I just want to, I note that at 491, where it says accepted and agreed to by BNP Capital Pty Limited, then it says by. It seems to me that there was meant to be something along the lines along by or below by, but before who warrants that she or he is duly authorized. And then below that, then
Yes.
there should be a full name and so on. Now, no name or signature appears alongside by,
Correct.
and no name or signature appears before by and who warrants. But there is a full name provided under who warrants, and that's the full name.
Indeed.
No, it may be that there was just a misunderstanding of what was meant to happen here. But one just has somebody who has put in a full name.
Indeed.
There's no signature as such, which might not legally, mean any difference if it's the same person who wrote his or her name. But I just noticed
Indeed.
that there seems to be something there.
Chair, I will specifically make a note of that because we will be having evidence from Mr. Mahlangu. So
Yes.
it is indeed he who
Yes,
can likely clarify
yes,
this aspect for
yes,
us.
yes.
For present purposes, just working off the text of it,
Yes.
notwithstanding the concern you raise with respect appropriately because there is no signature, the only thing we do see here is some acknowledgement from
Yes.
a person indicating to be authorized as a director of BNP
Yes.
on the date, the 3rd of June
Yeah.
2016.
Yeah.
I'd say that's the high watermark of what we can make of the document.
Yeah, no, look, if, to the extent that the person who put his name here is Mr. Mahlangu, it would be difficult for him to indicate what purpose he put his name
Indeed.
here for other than to accept.
Indeed.
Yeah, so
Indeed.
it might just not have been done in the manner that was really contemplated.
Precisely.
But the purpose must have been then to accept.
Indeed.
Yes.
Indeed.
And then let's go to the page that I missed.
Indeed.
Yes.
It's over the next tab, Chair, which is 47, and it's page 494.
Yes, I've got it. I missed what the two of you were talking
Indeed.
about there. I apologize because my mind was still on the other
course.
page. Maybe
Chair,
if you
let me
could
go
just,
over that again, if I may.
please. Yes, please.
What I was seeking to explore with Ms. Stimpel is we now have a letter. This is at 494, which is dated 25 May 2016. And it's a letter that, Ms. Stimpel, you then refer to at paragraph 108 of your affidavit, which is at the bottom of page 19. And it's a letter which begins, "We acknowledge with thanks the award of this mandate and hereby graciously accept it." So this seems to be, at least on its face, an earlier acceptance than the one that we saw dated 3 June. But it goes on in the same breath as graciously accepting the mandate to start talking about what would happen if there is a cancellation of the mandate. And you will pick that up in the penultimate paragraph of that letter, where the following is recorded. They say this is to ensure, they've been talking about the efficient funding package that they're wanting to obtain. And they say this is to ensure that we deliver on all the mandates entrusted to us by SAA. Accordingly, should SAA decide to unilaterally terminate our services ahead of us fulfilling our mandate, for whatever reasons, on any matter outside of our control, a cancellation fee of 50% of all the fees as per our proposals to SAA shall become due and payable in 5 working days following the cancellation notification date, looking forward to our partnership with SAA in ensuring its successful turnaround of its business. Now, Ms. Stimpel, can you just help us there? What would 50% have been of all the fees as per the proposal that was then accepted by the board on the 24th of May?
It would have been 50% of the 225 million, if one included VAT, 256 million. And then the other fees as transaction advisor of 2.68 million, and then 50% of that. So that is quite substantial.
So
Given-
the actual amount would be how much? 50%?
We'll have to do a quick
About
calc,
112 million plus another 2 is 114 million,
Yeah,
right?
almost,
Yeah.
yeah.
Excluding VAT.
Okay.
Talking about, yes, in the order of about
120
115 million. Is that right, Ms.
Correct.
Stimpel?
And I see that, Ms. Hofmeyr, that the date of that letter is the same as the date of the other one that
Indeed.
we were talking about.
Indeed.
Yeah.
The curiosity is,
Yes.
though, that on the actual letter of award, the signified acceptance is dated a matter of days later, the 3rd of June. But at
Yeah.
least this letter is the same day. So
Yes,
there's an
yes.
exchange on the 25th of May as we have it. SAA sends out its letter of award. BNP sends back this letter in which they indicate a gracious acceptance of it, and they immediately say, if this thing is terminated at all, we want 50% of our fees, which Ms. Stimpel has clarified for us at that point stood at about 115 million. What's your experience of cancellation fees in these types of arrangements? Are they customary?
They're not customary, sir. For your own business and someone like a company like SAA, who every single manager has been tasked to save costs, in fact, every single person, every employee in the company, we would not be negotiating a cancellation fee in any of our contracts. They are service providers to us, and if they're unable to provide that service, we terminate the contract. So why would you then, against your best interest for that organization, put in a cancellation clause? If you, on the other hand, SAA servicing someone else, they can put the cancellation clause in. So this for me, and which is strange, I did not have sight of this document while I was still in the employ of SAA. I only got sight of it much later. And having seen that from the date of the award, if the round robin happened on the 24th, board approval. The 25th, the letter goes out as a letter of award. The 25th, our client comes back, BNP, already putting an cancellation clause in there, and you're asking yourself why. They haven't even done any work. How would you even justify putting in that clause? Normally you put it in after you negotiated this is just a letter of acceptance. Then you negotiate your contract and the agreement, and in that agreement you're going to then discuss those type of aspects. And so for me, this was really, I would say,
Quite
curious
unusual.
to find this, that I could see this right in the letter up front. Correct, Chair. Thank you.
Mr. Paul, quite a bit was happening on the 25th of May of 2016, because on that date, and if you go over to the next tab, 48, at page 496, there was a letter from the then Minister of Finance, Minister Gordhan, to Ms. Mieni as the chairperson of the board of SAA. You've also referenced that in your affidavit at page 110. Just to clarify, were you aware of this letter at the time?
No, Chair, I was not.
But
I'm sorry, did you say page 110?
Sorry, page 496.
Oh, okay.
Apologies, Chair. I think it was behind tab 48.
Did you say it's a letter from the Minister of Finance?
Correct. At 496.
Oh, okay. I've got it. Thank you.
Thank you. You weren't aware of it at the time, as I have your evidence, but I'd like to ask you one or two questions about it, because it appears to be an indication, at least from the Minister of Finance, conclusively indicating that the proposed engagement with the Free State Development Corporation is beyond the mandate of that entity. You'll find that in the second main paragraph on that page, where he indicates that he'd received an earlier letter from the board on the 15th of March, in which the board had indicated that a due diligence was being conducted on the Free State Development Corporation, which was SAA's preferred bidder. Chair, that's just important for us to know what was going on. So still in March 2016, the Free State Development Corporation is still being engaged with as a potential funder. But you'll recall from the evidence yesterday that as early as January of that year, Ms. Stimpel had relayed back to the interim CFO Treasury's view that this was beyond the mandate of the Free State Development Corporation. But at this point, we have an indication that still in March, though, those endeavors are continuing. And then it goes on, the letter, to say, in the last few days, I've received a letter from the member of the Executive Council for Finance in the Free State Province, reporting on an investigation conducted by the Provincial Treasury regarding the loan offer for 14 billion from the FDC to SAA. Says, based on the investigation, it is evident that the process of obtaining funding from FDC contains material flaws. Even if these could be resolved, the process would be protracted, and SAA would be unlikely to be able to secure the financing within the required timeframes to settle the maturing debt. And then it's the last paragraph that I'd like to have your comment on, What the Minister concludes with is that, consequently, I have concluded that SAA was unable to conclude the debt consolidation within the specified deadline. Therefore, I request SAA to immediately begin the process of refinancing or rolling over the 6 billion in guarantee debt maturing in June and July 2016 into longer-term debt. This process must be finalized by 31 May 2016, as per my original letter. What do you understand that to be conveying to the Board of SAA?
What I understand there, Chair, is that the Minister of Finance is directing the Board of SAA, saying that we've noted you have not been able to do the debt consolidation, which we've confirmed throughout the process, and therefore to continue rolling our debt over. With the refinancing means finding other funders. If, for instance, a Standard Bank does not want to continue with the funding, we get a Citibank or a Standard Chartered or a FNB, or you roll it over with the same bank, and which we have been doing the past years in the same process. And so they were directing us to continue that process, seeing that the debt consolidation was not happening. Thank you, Chair.
And just in terms of figures, the debt consolidation was really what the 14 or 15 billion was aimed at, was it not?
Yes, at the time it was roughly about 14 billion. If we look at the letter, the date of the letter, in May, correct. And that was also the extent of the full guarantees.
Yes.
So it was backed 100% security with government guarantees.
Thank you. And then
I'm sorry, what was that? Was it two different things, 14 billion and 15 billion, or was it one thing?
The 14 billion, sir, is, Chair, is the amount of the government guarantees that the National Treasury has given SAA. The round figure of it, because it's 14 point some odd amount, the 15 billion was the round figure for the debt consolidation.
Okay.
Correct. Thank you, sir.
it's difficult when you've got 1 billion floating around to be sure precisely where to locate
now
it.
some correspondence talks about 15 billion, others 14, so you get confused.
No, I agree
Okay.
and noted, Chair.
Okay, all right.
Ms. Stimpel and Chair, just for record purposes, but I'm not suggesting we go there. That letter that the Minister of Finance refers to, having received from the board of the 15th of March, is the next annexure, but it records correctly, as the Minister records it, that in March there is still a due diligence being engaged upon in relation to FDC. But I'd like to then move on from there to another letter in the sequence. Chair, this is a letter which appears at page 503 under tab 50. It's a letter again from BNP Capital addressed to Peter is the recipient at 503. Ms. Stimpel, again, I take it you were not aware of this document at the time.
No, Chair, I was not aware of this document.
Chair, from this
that
point
time.
on in Ms. Stimpel's affidavit,
I'm sorry,
Yes.
that's at page
503.
503. Let me get there first. Yes.
Chair, this is a letter, what appears to be from BNP Capital to somebody named Peter. Ms. Stimpel has clarified she was not aware of this letter at the time.
The one I have at 503 is from Mr. Matlangu to Peter.
Correct.
Yeah,
Correct.
okay. Same letter.
Indeed. Mr. Mahlangu being the representative of BNP Capital, whom we've seen on the other letters. Chair, Ms. Stimpel's affidavit, in some parts from now on, deals with this correspondence, which was given to her by the investigators of the Commission. We have subsequently engaged with Mr. Pieter van der Merwe, who is the addressee of this letter, and he is in fact the witness giving evidence later today.
Okay.
So it is my
okay.
suggestion that we pass over those aspects with Ms. Stimpel.
Yes.
We'll engage them directly with Mr. van der Merwe.
That's fine, that's fine.
Thank you.
Thank you.
I'd then like to move, Ms. Stimpel, in your affidavit to page 21, because we are going to skip over those letters. We'll engage on them further later in the day with the next witness. But I'd like to come to paragraph 115 on page 21 of your affidavit. Because it's in that paragraph that you talk about a meeting that was held on the 3rd of June 2016 between National Treasury, SAA, and SAA's funders. Can you please tell us about that meeting? Did you attend it?
Yes, I did.
And who from SAA was in attendance?
We had Ms. Nahansi was there. It was myself. It was Mr. Joshua, I think it's Duplessis. It was Lindsay Olitsky. There was the lady from Fleet, Alsha, Duprier, and I think that was it.
Can I just clarify, were there any members of the board present at that meeting?
No, there were no members of the board present at that meeting.
And then tell us what occurred at that meeting.
So on a regular basis, Chair, is that we meet with the banks together with National Treasury for various reasons. The one is that National Treasury is providing the security to SAA through its loan book, through government guarantees. And secondly is that SA needs to present, A, its financial results, B, its where it is going with its long-term turnaround strategy, and how it's doing generally from a financial operation perspective, but also from its airline operations, from its ground handling to its routes, etc. And so on a regular basis, and this particular date was chosen the 3rd of June, which we held at National Treasury's offices, and there SAA made presentation to each of these banks, showing them our standing, where we are currently with our financial situation, also reflecting what our routes are, which are our best routes, where we're struggling, what the we are with our aircraft, etc. So it's an all-round overview of the business. This is presented to each of the banks, but separately. A, because of the confidentiality surrounding the information, not from a SAA perspective only, but also for the banks we're dealing with, because you have a different relationship, a different loan percentage-wise, and sensitivity and exposure to each of those banks. So when we present to each bank on its own, so be it a Citibank, be it a Standard Chartered, be it a Nedbank. And so we presented to each of these banks throughout the day. We started, it was from about 8:30 in the morning, we finished in the evening about 4, 5, yeah.
And just to be clear, was there any representative of BNP Capital in those meetings?
No, there was not any, Chair.
I'd then like to take you to a letter from BNP Capital, which you'll find at page 526, and that is under tab 53. Now that is a letter, as I have it, from BNP Capital to South African Airways. It's a 3-page letter. Chair, it's a letter we will return to this afternoon in the evidence, but there is a reference to this meeting in the first paragraph on the first page on the 3rd of June 2016 between National Treasury, SAA, and SAA's funders. And then it appears to record the key points of those meetings. Do you see that, Ms. Stimpel?
Yes, I do.
And those points 1, 2, and 3, are those some of the points that were covered during the meeting?
Yes, correct. Okay, thank you.
Do you know how BNP would have learnt of the contents of those meetings?
I actually do not know, because this was only the team that were working, obviously, at SAA, and then presenting directly to the banks. For BNP to have got this information had to be someone who was part of the team that was present on the day.
Does it surprise you that they were given this information?
It does surprise me. It should not have been told to BNP.
Thank you. I'd then like to focus on the second page of that letter, which you'll find at 527. That is where there is a heading GRISAG AG, the entity whose director will be giving evidence later. A detailed account there is given of the costs that GRISAG by that stage had incurred in sourcing funding, and this is presented as I read the letter, a justification for that cancellation fee that they were motivating for on the 25th of May. But it concludes on the following page at 528 with a capital lettered request to SAA, which reads as follows: our primary urgent request to SAA is to sign off the term sheet indicating its preferred choice. This is a reference, Chair, to the term sheets that had been provided by GRISAG AG at that point in relation to the terms on which it was willing to fund. And it goes on to say, importantly, this is what BNP is asking for, that that term sheet must be signed. Importantly, omit the write-up not binding. This is stating the obvious, and forward same before the close of business today to enable the directors currently in Paris to get on with the work of finalizing the raising of funds for and on behalf of SAA. Ms. Stimpel, as I read that, and I'd like your comment on this, it is asking for a version of the term sheet to be concluded that does not contain a non-binding caveat. Is that as you read it?
Yes, that's how I also understand it.
Thank you.
Thank you.
And you go on in your affidavit to indicate that it appears from the documents that you've been shown that that request was in fact acted upon by SAA. And the cause, as I have it for your comment in that regard, is the next item, which you will find at page 530. What is that document, Ms. Stimpel?
This is a term sheet as well, a term loan facility done by GRISAG and for the client SA.
And if we just page through it.
And I see it's on 25 May.
Yes.
Yes.
A lot happened on 25 May, Chair. But what you will see from the last page is that it was actually signed on the 8th of June by the SAA representative. But let's go there, because over the first page there are what I take to be the terms of the term loan facility. It identifies the parties. As a borrower is South African Airways, lender is GRISAG AG, the guarantor is the Government of the Republic of South Africa. It moves on to deal with the terms of the facility. If we turn over the page, pricing, repayment, representations. Over the next page, miscellaneous. Now, Chair, we'll get into this in more detail with the evidence later today, but usually on that fourth page, 533, under that last part of the table, there's a whole lot of language about this being non-binding. And that is now not here on this page. The caveat that it's non-binding has been removed. And if you turn over to the last page, you'll see at 534, the bold at the top, by our signature, we hereby accept in principle the terms of this term sheet. And that is signed, as I have it there, on the 8th of June by Ms. Nhansi, the interim CFO. We'll also explore that with her.
Well, GRISAG signed on the 25th.
Indeed,
of me.
indeed. Well, the evidence this afternoon will give
might
you greater
change that.
insight onto that.
Okay.
As I have it, it actually occurred at a meeting with GRISAG on the 8th of June.
Oh, is that so?
But our later witness will clarify that
Okay,
for us.
okay. Maybe it had been contemplated, it would be
Indeed.
signed on the 25th.
Indeed.
Okay, all right.
But the significance for present purposes, Ms. Stimpel, is, as I understand your affidavit, there's that letter of the 8th of June that comes from BNP talking about a meeting to which they did not attend on the 3rd of June.
Correct.
Indicating what was discussed at that meeting in circumstances where you've queried their receipt of that information, given the confidentiality of those discussions. Is that correct?
That's correct.
And then on that day, it appears that the interim CFO of SAA did precisely what BNP was requesting, which was to return a term sheet signed that did not contain that non-binding caveat. Is that correct?
Correct, Chair.
Is that, I know you weren't aware of it at the time, but is that a source of concern for you?
That is indeed a source of concern.
And why?
Well, that we would sign a non-binding sheet. Secondly is that we haven't gone through, with all the background to this, for our interim CFO then to sign it and then not take, push SAA into this, for me is definitely a concern.
Thank you.
Are you saying that the basis of your concern is that there were a number of unusual features about how it was gone about?
The whole process from the start, when we
Yes.
already started through the initial process of procurement, getting the FTC, then finally we come now to the BNP. I'll tell you where my main concern is, if I can be more specific rather,
Yes.
in that SAA engaged BNP as a transaction advisor. Then they changed it to sourcing of funds now. And so the agreement now is done through GRISAG, who is going to be providing the funds. And just looking at this, you'll see now GRISAG is offering a 3.5% in their fee, that, but they're adding 1% payable on each drawdown as SA takes out the money, depending. So there's even more issues as one looks at this, that if you start calculating the cost would incur. And I'm not sure if that was thought through, because then you would say, my final cost, once you agree, you would also look at your final cost. Yes.
We've seen previous BAC scorecards or checklists, you'll recall from yesterday, that requires all sorts of things like risk assessments to be done, financial impacts to be done. Are those the sorts of processes that you would want to see occurring before conclusion of this type of in-principle agreement?
Yes, and especially from a term sheet of funding. We've got others from Standard Bank, ABSA, etc., and those are gone through, again, in Treasury Department, because we've worked with the finance. This, none of us in Treasury were privy to, not the head of cash manager, Michael Klein, who looks at these term sheets on a daily basis. He was not privy to seeing this, and then this is being signed there and putting SAA at possible risk. Yes, thanks.
I'd then like to move, we're at page 21 of your affidavit. Again, at the bottom of that page, you reference certain correspondence between BNP and SAA, which you were shown by the investigators. But again, that is correspondence actually with Ms. Nhansi, who will be giving evidence. So my suggestion is that we move to that with her in her evidence, Chair. So we can go over the page, if you will, Ms. Stimpel, to page 22. And at that page, there is a heading, Whistleblower. And it begins thereafter at paragraph 122, where you say, after the board approved BNP to provide funding requirements, I was left feeling extremely uncomfortable about it. I found the following aspects particularly disturbing. Can you tell us, you've summarized, as I have it, 4 issues in your affidavit, but talk us through what they were in principle.
For me, it was the whole process of just the way we have gone, the approach we've taken to secure funding for SAA. We've diverted from the traditional way and our historical way of sourcing funds, in that we went to the banks, we went to an RFP. So by even getting external new parties on, we still should follow a proper RFP process. What we've done is we've added in names, we've then brought in a transaction advisor, changed the scope of it to widen it to source funds, hereby also going against the scope of 50. If you're changing the scope, it's only 15% of costs, which is far more, so we've already gone against that. Then secondly is, once we've procured this transaction advisor, the fee was at 1.5%, the final fee that was decided on, from 3 to 1.5, and still a phenomenal amount of 225 million to be paid to this party. And the fact that Treasury Department was not involved in this made me feel totally uncomfortable, and I felt that I needed to do something about it. Yes, I did talk to 2 of my colleagues, Michael Klein and Silas Mtsautsi, at the time, and said to them, you know that this process was not done correctly. Can we stand together and speak up about it? And they both said no, they need their jobs. They're not going to do anything. So I said, well, I cannot sit by and let this happen. I need to speak about it. I also consulted with my family, etc. The risk was that I would probably lose my job should I speak out. And I said that should I resign, it will come out later anyway. And they'll say, who was the person in that position? Who was the group treasurer? Why didn't they do something about it? And I said, I have to take the risk and I have to speak out. And so on that basis, I decided that I will become a whistleblower and speak out on it.
Thank you. I'd like to take you to page 23 of the statement, the affidavit at least. At the bottom of that page, at paragraph 1 to 4, well, around the middle, you talk there about really, it's a reference back to your first steps, I take it, as a whistleblower, which was the WhatsApp message that you sent when you were on the pilgrimage in France. But you record there at paragraph 124 what the response had been by that stage from National Treasury. Can you tell us about that?
Yes, after sending that WhatsApp message, I didn't receive any response from Treasury at the time.
Right. We will come to when you did have a response. That comes later. But then tell us about the next paragraph, 125, where you went to see another colleague, Mr. Joshua Duplessis. What were you going to speak to him about?
I had already drawn up a draft letter, whistleblowing. I had done some research about it. And I thought, now, how do I approach it? Who do I approach within the organization? Because you also need to go to your next seniors. And for me, my next best senior would be my boss, who was at the time Ms. Nahansi. And I was reporting about her going ahead with the BNP and not being open to listening what I had to say, not being open to hold back the RFP, or just open the RFP or start a new RFP, but rather go ahead with the BNP and with the fees that we were going to pay BNP. So I drafted my letter. I made an appointment with Mr. Joshua Duplessis. We met in his office, and I showed him the letter, and I said, look, this is what I would like to disclose. I just need your guidance. I think you're the next best senior person I can speak to, because he was on the executive committee. He was the executive of strategy at the time. And I thought that would be the best. So we had a discussion, and his advice to me was, Cynthia, do not go the internal route, because if you do, it goes directly to board, and board will suspend you immediately.
He also, as I have paragraph 125, made reference to an example of another colleague. Can you tell us about that?
Correct, he did. He mentioned that there was a case prior to mine regarding the Airbus deal. There was our head of operations at the time, Mr. Sylvain Bosque, who then also reported through the normal internal whistleblowing process within SAA regarding the Airbus deal. He was then suspended from SAA.
And then, as your affidavit progresses, you talk about those interactions with your family that you've traversed in your testimony this morning.
Maybe I'm sorry, before that,
Yes.
is that where that story ended of the colleague who had been suspended, as he told it to you? Or did he ultimately get dismissed?
Thank you, Chair. He's went on also for more than a year, back and
On
forth.
suspension.
On suspension, back and forth through obviously trying to have a hearing. And eventually, when they finally had his case, he won his case. And in his case was that SAA had to re-employ him, but SAA ignored everything. He then took it back to his lawyers. They had a follow-up hearing on that, and he ultimately won his case with damages. SAA had to pay his lawyers, and he then left the company and is now working at a new airline.
Oh, okay. That was just important because here you, as I understand, you were being told this to say, look what happened to so and so.
Correct, sir.
And while suspension has its own place in the whole thing, it's also important to know what ultimately happened.
Indeed, Chair.
Okay, but one of the things is that he was suspended for a long time.
For a very long time, sir.
Yes, okay, all right.
Thank you, Chair.
Thank you.
You carry on, Ms. Stimpel, in your affidavit dealing with your engagements with your family. I take it that this was quite an important and difficult decision for you, given the extent to which you engaged with them. Is that correct?
That's correct, Chair.
And then if we go to page 24, paragraph 128, because there I pick up the response that you received from National Treasury on the 23rd of June. Can you take us through that?
I received a call from Mr. Hiho du Toit at the time, asking me if I was still willing to disclose and have I got the information ready for them. And I said, yes, I do. And that, is it possible for us to meet somewhere? And he agreed. And so I did meet with Mr. Hiho. I placed all my documents onto a flash disk, my cover letter stating that this was a whistleblowing information that I was giving. So following the principles of a whistleblower, and then listing all the issues in a chronological order, listing and attaching all the documents, and which I then provided to National Treasury, Mr. Hiho.
Ms. Stimpel, can I just get a point of clarification there? Because your affidavit goes on, and we'll deal with this evidence shortly, about your efforts to get documents that were relevant to parts of this procurement that you were not aware of at the time. So can I just clarify, what was it that you gave over to Mr. du Toit in relation to documents you had?
Okay, so it was based everything that I had at the time, which started with December's board resolution, which I found was extremely irregular. The one we saw with the letter being circulated at board yesterday, which we discussed, that I was extremely uncomfortable with, and that I'd already raised to National Treasury at the time, and then obviously when the FTC came in. So that was part of the documents. It was the documents I had on hand, as in first the transaction advisor, and then how we changed from transaction advisor to now source the funding. So basing all those information that I had up to date. What I did not have was any of these letters regarding BNP, because I was not privy to those at the time. Thank you, Chair.
And as I have it, you also did not have the BNP bid submission at the time.
No, at the time I also did not have that. I only had that once I had taken it myself.
In the next month.
In July.
We'll come to that.
Okay, thanks.
Thank you. And you conclude at paragraph 128 to say that he came and collected the documents and you did not hear anything further from him in this regard. Is that the end of the story of your engagements with National Treasury on this topic?
Yes, I've not then spoken any further to them except when we had our normal meetings, but that is us presenting our SAA, either financial standing or what's happening on the funding or what's happening on our cash position. Correct, but nothing related to the whistleblowing issue. Thank you.
At page 24, paragraph 129, you talk about receiving a call from Ms. Tuli Mshe. What was that call about?
Okay, Ms. Tuli Mshe was our head or general manager of human resources. At that time, we had the telephone discussion. She was already suspended from SAA. She acted as CEO for SAA for a time, and then she was taken off and Mr. Musa Twani was brought in. She was then brought back to GM HR and subsequently was suspended. And so I kept in contact with Ms. Mshe more because I was concerned about our colleagues that were getting suspended. And she was one of the staff I reached out to when I told her that I would like to whistleblow. So on this particular day, she returned my call and we spoke. And I also indicated to her that I intended to whistleblow, and I gave her the background to all the information that I had and why my concerns were so relevant and why it needed to be done. And she then gave me advice as well and said, report to National Treasury. So I said, I have done that. And she said, report to the Public Protector, and also then gave me an additional number. She said, Outa, who's normally involved with ETOLs, have changed their mandate and looking at any abuse of taxpayers' money. And she gave me a contact number to phone. Thank you, Chair.
And as I understand your evidence in the affidavit, you did follow suit on both of those legs, both the Public Protector and Outa. Can you explain what you did in that regard?
Thank you. Yes, I did that, Chair. So I first started with the Public Protector because I had actually saved a flash disk which I thought I could go over to the offices and give it. But then I Googled and to the website, and I came up with, it led me to the Corruption Watch website. And in there it said type out your query, which I did. I typed out the query, which was actually limited, so it wouldn't, a limited amount of letters or words you could use. So I had to reduce it, and I was quite brief in saying that I have a matter of urgency, which I'd like to whistleblow on. I gave my details, my cell number, my email, etc. And I said, I'm prepared to whistleblow on that. And I gave a rough essence of the matter, being that this is the amount and this is the company SAA, etc. I did receive an acknowledgement from the email saying, thank you for your inquiry, we will get back to you. I didn't get anything back from them. I was waiting. And the next step was I then, the telephone number I had from Ms. Mshe was Wayne Devenage from Outa. I called him and told him that I have a matter which I'd like to disclose. And he said to me, well, let's set up a meeting, and we'd set up a meeting for the 1st of July. Thank you, Chair.
Ms. Stimpel, you appear from the evidence that you've given to have regarded this matter as urgent. Why was that?
My concern was that we were going to pay out 225 million for obtaining the funds. So yes, I was fully aware that SA needed the funds, and at the same time we were paying expensive debt and rolling it out, but it shouldn't have cost us 225 million. And I felt it is my duty, as a SA employee, but also as a South African citizen, to be mindful of not wasting money, of not just being part of the process that everyone was engaging in, as we read newspapers throughout the time, that money was just being wasted on unnecessary procurement transactions for little gain and value to the organization. So I felt if there was anything that I can do to either stop this or prevent this from happening, I was going to do it. Thank you, Chair.
And at page 25, paragraph 131, you reflect on that meeting you had with Outa on the 1st of July. What happened in that meeting, and then what steps did you take back at SAA thereafter?
So we had, I had handed over my, the flash disk with all the information. There was a team there with Mr. Duvenage and his team from Outa. They had gone through, they had their laptops, they had gone through all the information, and they asked a lot of questions as we were going through, obviously, and then asked me if I had seen the BNP file. And I said, no, I'd not seen their bid document at all. I haven't had the privilege yet to see it. And I had asked in the initial stages, around March already, when the client was first approved. And then I got so busy because it was our year end and various other key issues that landed on my desk that I needed to take care of, that I had it at the back of my mind and I just didn't do anything. And they asked me, would it be possible for you to see if you can get the document? And I said, yes, I will try and get it. I will ask the commodity manager for it. Thank you.
And that, as I have it, is what you did then on the 4th of July. This is picked up at paragraph 132 of your affidavit. What steps did you then take to seek to get access to those documents?
So on the 4th of July, I'd gone to Mr. Silas Mdzautsi's office to ask him if I could get the documents from him. He wasn't at his desk, and I asked his team around him, where is he? And they said he's in a meeting. So I said, please let him know I was around, if he can come see me. And I went back to my office. I continued with my daily work. The next day, a couple of hours later, I went back to find out if Mr. Mdzautsi was back at his desk. He still wasn't there. And I came back to my desk, and I went again. I went there a couple of times, probably 3 times already. By the end of the day, I went again. It was about 4 o'clock, and I thought, no, he must be back at his desk now. And I went there, and he still wasn't at his desk. They said, no, he's already left. He's gone home. And then I said, oh, please tell him I need to speak to him urgently because I need to review some documents. As I turned away from his desk, I found these documents all lying on the floor, lying on their side, and I read the name on one of them on the side there, stating BNP bid document. And I thought, here's the document just lying on the floor. So I took the document and I brought it back to my office. I went through the document, found some information there which I did not know about and which I knew would strengthen the reason why we should not be dealing with BNP. And so I scanned the document to myself. I went back to the office to put the document back, and by then the office was there. Office was locked. They have an open plan. And so I left the document on my desk. The following morning, I came back to my office. I then took the document and I went to Mr. Silas Mdzautsi's office to tell him, look, I wanted these documents. You weren't here the whole day yesterday. So I just wanted you to know that I did take the document and I did scan it, and I'm now returning it to you. And I gave him back his documents. Thank you.
And what was his response when you did that?
Mr. Mazzazi, to my surprise, got very angry. And he said, "How could you take this document without my permission?" And I said to him, "Silas, you know that this guy is supposed to be doing sourcing, this company is supposed to be doing sourcing of funds. That is my area in Treasury, and I should know about this client. They have not once come and spoken to me or any of my team, and I wanted to know more about the client." And he said, well, he's going to report me to the procurement head, which is his boss, and to the CFO, who's my boss, Pumeza Nahantsi.
And that, as I have it, took place on the 5th of July. Is that correct?
That's correct. It took place the next morning, yes.
I'd then like to take you just back to the 4th of July in the sequence, because your affidavit at paragraph 135 on page 25 picks up what else happened on the previous day, the 4th of July, because that is when a motivation was addressed to the board to seek approval for that cancellation fee that we looked at earlier this morning. Chair, by this stage, however, the cancellation fee had reduced from 50% of the total fees to an amount of 49.9 million rand payable to BNP Capital. There's some significance in the reduction of that amount, but it will come out in further evidence. But I'd like to take us to that document which motivates to the board for approving this cancellation fee. You'll find it under tab 59 at page 555, 555. And that document is from the interim CFO, as I have it to the SAA board. Ms. Stimpel, were you aware of this at the time?
No, I was not, Chair.
And if we just look at it, the purpose is to request the acting CEO and the board to approve the cancellation fee that the transaction advisor will require should SAA terminate the mandate of sourcing the funds. And it then proceeds, as we've seen, these are quite standard form motivations. It's a purpose, and then a motivation is offered, a recommendation, and then a note on the financial implication. The first thing I'd like to just look at on that second page, 556, is who the compiler and who the recommender of the document are. Who are they, Ms. Stimpel?
They are the interim CFO, Ms. Pumeza Nahantsi, and the recommender is the acting CEO, Mr. Musa Twane.
And if we can go back to page 555, can you take us through what motivations in the bullet points were offered for this cancellation fee? If you start at the first bullet point, it seems to be related to the extensive fundraising exercise that had been engaged upon. Is that correct?
That's correct. So it states here, BNP Capital, from the date of the mandate from SAA to put together a dedicated team of professionals with various expertise and track records in the fulfillment of the mandate. The fundraising exercise included consultation from their global partners like China Development Bank, Etihad in Abu Dhabi, Brazil, Canada, and Europe, Grisak AG.
And then the second motivation?
It states there that this exercise entails continuous incurring of both man hours and disbursements in the coordination and the execution.
The third motivation over the page?
That BNP Capital has engaged and tasked Grisak AG to find a total of 15 billion from its various long-term investments around the globe. And the fourth one goes, Grisak AG has incurred the breakage cost in breaking up the investments.
And so the recommendation, as I have it there, is that this cancellation fee If you go down to financial implication of 49.9 million, should be paid to BNP Capital in the event of a termination of the mandate. Is that as you understand it?
Yes, correct. That's how I understand it.
Chair, the evidence, or at least the documents, reveal that that recommendation then went to the board, and the only member of the board who in fact supported it was Ms. Mieni. The other members of the board in fact did not approve the cancellation fee of 49.9 million. But I would like us just to take a moment with Ms. Mieni's response to the request for her approval. You'll find that at page 559. You'll see in the second half of the page, the email begins, "Dear SAA board member, attached herewith for your consideration and approval, please find the round robin in respect of the approval for the cancellation fee to the transaction advisor. Please kindly communicate your decision as indicated in the round robin form." And then we'll go to Ms. Mieni's response in a moment, but there is a persistent theme that certainly I pick up in this mode of operation in the board that we've seen through all of these documents, which is that they seem regularly to go for round robin decision making. Is that something that is customary in SAA? What would be your comment on its relation to good governance?
There are set board meetings. The timetable is set out by Company Secretary's office, so all meetings are scheduled a year ahead. So you have a full calendar of where your dates are. I agree there will be times where you will need a round-robin meeting because of matters of urgency, and then board needs to consider it. This particular one, I wasn't there at SAA because I was suspended by then. So on the 7th, I'm not sure. I don't think there was a board meeting in July. And so hence, this is the reason for the round robin which they put in. But there should be judgment calls made when which are urgent enough to put for round robin and which are not. The process we went through yesterday when to appoint the transaction advisor from a normal mandate as transaction advisor to now sourcer of funds, when there was a board meeting coming up the 27th of May, and to do it on the 24th as a round robin, to me did not make sense at all. So yes, the board does have a policy that we, normally for us, as employees, we have to stick with all the deadlines. So we're not allowed to put any documents through to round robin. And so I'm just surprised that, from what I've seen, that they have used it now as a habit. And I would take that as noted. Thank you, Chair.
And then if we can just go to Ms. Mieni's response, which appears at the top of that page. Could you just read into the record what she records there?
The 559 page.
Yes.
So she responds to Mr. Mdu Nyoni. Dear Mdu, does this need board approval? If so, I approve it. Regards, Ms. Dudu Mayeni.
Thank you, Ms. Stimpel. Chair, we will return to the importance, if any, to be attached to that email with further witnesses. Ms. Stimpel, if I could then go back, because I asked you to reverse one day, back to the 4th of July, so we could see what had been presented to the board on that day for approval. But you had already got in your testimony to the 5th of July, which was the date, as I understand your evidence, on which you returned the file to Mr. Matsudza, and you then engaged with him. As I have your evidence, he expressed concern about you having taken the documents. And let us pick it up then, if we may, at page 26 of your affidavit. And you begin telling this story from paragraph 128. That is where you record that Mr. Matsalza became very angry, and this surprised you as you'd not done anything out of the ordinary. He asked you why you'd taken his documents, and you said that you needed to see it. And then, as you recounted, he told you that he was going to report you.
That was paragraph 138. I don't
Correct.
know why I had 128.
Oh,
but
apologies, Chair.
138.
138,
Okay.
on page 26.
Yeah.
But at the conclusion of that paragraph, you tell us what you then responded to him with. I'd ask you to tell us that and then take us through what happened in the remainder of that day.
I told him that because it was a Tuesday morning and we normally had our weekly meetings with National Treasury, and I was on my way to the National Treasury's office, and I said to him, I have to go to a meeting with National Treasury, and upon my return we can discuss the matter.
And what happened when you were on your way to National Treasury?
So I had gone to National Treasury. At the time I received a phone call from Ms. Nahansi, and she told me not to attend the meeting, that I must return to the office at SAA, and that I should wait for her.
And did she indicate that she had received information from Mr. Matsalza?
Yes, she did. She said that he was with her. He had come to her office and told her that I had taken those files, and she wanted to, and she said, don't go to the office, don't go to National Treasury, because you're going to give the information to National Treasury. And I said, I am going for the meeting, and she said, well, don't go to the meeting, stay at your desk, and until I get back, she said she will attend the meeting, and she will then get back to me meet with me once she's returned. Thank you.
What could have been the problem with you giving those documents to National Treasury?
Personally, I don't think it should have been a problem. If you look earlier, when we were sourcing funds, especially on the consolidation, National Treasury has been involved in those meetings. They've looked at each of our bidders that we've had, which have been primarily the banks at the time. And even in the last one, where we had up to December and early January, when we included FTC, we had National Treasury part of that meeting as observers. So they were fully aware. Once we've engaged in the funding process with any bank, National Treasury gets involved because they provide the guarantee. And their legal department, together with SAA's legal department, and together with the funder's legal department, work together on drawing up the legal agreement. So with BNP, they would have had to know the company anyway. So if they had to see the documents, it was important that they also had to see if they were going to work with them, and they had to know who was the legal person. They had to draw up the guarantee regulations, terms and conditions with BNP, so they would have had to know that.
As far as you know, would there be any legitimate basis for somebody at SAA not to want National Treasury to know any aspect concerning a transaction that involves money that relates to SAA? Would there be any basis for anybody at SAA not to want National Treasury to know?
There should be no basis, sir.
Because it's not like National Treasury is a competitor to SAA. National Treasury is National Treasury, and SAA needs National Treasury.
Exactly,
And
Chair.
in many cases, it needs National Treasury's approval for certain transactions.
Yes, for each of our funding transactions, we
Yes.
need National Treasury. So
Yes.
strong it is, and SAA cannot function without National Treasury. They
So-
are the backbone, literally.
So you know of no basis on which anybody could object to National Treasury seeing
There should be
any
no
documents
basis.
relating
The
to
information
SAA on
should be
transactions.
correct, sir.
Yes,
Correct, Chair.
okay. Thank you.
Thank you, Chair.
Thank you. You indicate at paragraph 141 on page 26 that Ms. Nhansi also spoke to you about the media. What did she say?
She also told me that if this gets leaked out in the media, she will hold me responsible for that. And I said to her, why would I go to the media? I have no intention of going to the media. And Ms. Nhansi said, I will still hold you responsible for it. Thank you.
What is this that could have gone to the media?
This, I would say, is the fact that I had taken the BNP documents, the bid documents. She already knew that I was very much against the appointment at the time of the BNP becoming the source of funds and the phenomenal fee that we were going to pay them. And she knew I'd objected to that. And now that I wanted to see the client and see their profile and to see whether they do have the capacity and the capability to provide the sourcing of funds with SAA. At that time, I had no idea even that they were dealing with GRISAC. So for me, I needed to satisfy myself that this was a company that was above board and could do what it said it was going to do and was worth the value that it was going to be paid, although I won't say worth it, was for me is how could they still be charging this value? And that was what I had at the back of my mind. So to go to the media, I think that's what she was referring to, that I would leak out the information around BNP to the media.
And then at paragraph 143 on that same page, you talk about what happened towards the end of the day when Ms. Nhansi called you to her office. Can you take us through those events?
So yes, I thought she would call me to the office around 12 o'clock, but that was midday, nothing. In fact, I did go up to her office and I was told by a secretary that I must wait at my desk, they will call me. So I went back to my desk and continued doing my normal daily work. And at 4 o'clock the afternoon, 4 p.m., I was called to come up to her office.
Before that,
Yes.
I see that at paragraph 142, you say that she instructed you not to attend the meeting at National Treasury. Did you comply with that instruction?
Yes, I did. I was actually on my way to National Treasury's office that particular day, sir. I had taken my car in for a service. So I was traveling with a colleague, Ms. Lindsay Olitsky, and we traveled together. So that's when I received the call. And we were almost in Pretoria at the time. So I told Lindsay about it, and I said, look, I better not attend because it would be seeming that I'm going against her orders. And so I sat at a coffee shop while Ms. Olitsky attended the National Treasury meeting. When she finished, she came back, and we were back in the office by 12.
Okay, thank you.
So I did not attend, yes.
And then you talk at 143 in your affidavit about when you did manage to meet with Ms. Nhansi. What happened in that meeting?
I came into the office. It was Ms. Nhansi's office. And in the meeting was Ms. Nhansi together with Mr. Makwela. I did not know him. I had no idea who he was. He introduced himself as the
Mkwena or
new...
Manele?
Thank you, sir. Manele.
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 Mr. Mbongeni Manele, M-A-N-Q-E-L-E, that is Manele.
Manele.
Okay.
Thank you, Chair. I entered the office, and the two people were sitting there, and I greeted and sat down, and Ms. Nhansi, in front of her, had a letter, and she pushed it across to me, and she said, "This is your suspension letter." And I said to her, I thought we were going to discuss what happened, why I took the documents, can I explain my side of the story, why I needed to see the documents. And she said, don't explain anything to me, you've been suspended, sign the letter, And I said to her, do I have any legal recourse? And she said, oh, you can go to the CCMA and you need to find your own legal representative at your own costs. I read through the letter. It stated that I had obviously, I've been suspended due to taking confidential information that was lying on the floor, confidential information that I was not privy to according to the statement, and that I have therefore been duly suspended until further investigation.
And Chair, I note we at the tea break, but if we could just go to that letter to
Yes.
conclude it.
Okay.
You'll find it at page 570 under tab 61. And if you'll
Yes.
just read the first paragraph, because it just records what you have recollected about the terms and basis for your suspension.
It states here that you are hereby notified that you are suspended from work from
I'm sorry, I thought I got the page
Pardon,
right,
sorry.
but it looks like wrong.
570, Chair.
570. Okay, thank you, proceed.
Thank you.
Thank you, Chair. I will start again. The heading says notification of suspension from duty. You are hereby notified that you are suspended from work, an investigation, and/or the outcome of a disciplinary hearing, which includes, among other things, removal of company confidential tender documents without permission from procurement. Your suspension from work will be on full pay.
Thank you.
Chair.
Yes, thank you.
Chair, we'll take up the, with your leave, the next events after the tea break, if that's suitable.
Yes, thank you. We'll take the tea adjournment and resume at 11:30. We adjourn. You may proceed.
Thank you, Chair. Ms. Stimpel, I understand that there is a further point that you wanted to make in relation to that term sheet that was signed on the 8th of June by Ms. Nhansi on behalf of SAA and GRISAG AG. What was that point? Ms. Stimpel, if you'll turn on the microphone. Thank you.
Thank you, Chair. Having looked at this term sheet that Ms. Nhansi had signed with GRISAG on the transaction for the 15 billion, my thinking
Okay,
was...
I'm sorry, that term sheet is on what page again?
Chair, let me give that to you. It commences...
I think when we took the adjournment, we were on the letter of suspension.
Yes.
That's correct.
Yes.
We'll have to go back just to page 530 for that term sheet.
Okay, thank you.
It's under tab 54.
Okay, thank you. You may proceed.
Thank you, Chair. Just looking at the term sheet dated 25th of May 2016, which was signed by Ms. Nhansi, but the date was the 8th of June. Even in that point, I thought Ms. Nhansi had an opportunity then to probably stop the whole payment that was going to be made, or shall I say the transaction with BNP, because one could have then said, you know what, here's GRISAG offering a far better rate, come out with a new RFP completely, put new critical criteria that would include clients like GRISAG who can deal directly with the SAA and rather than going via a middle person. And so I thought this would have been an ideal opportunity for her to also do that, but I see that opportunity wasn't taken, and that's what I wanted to raise. Thank you, sir.
Thank you, Ms. Stimpel. If we can then return to page 27 of your affidavit. We left before the adjournment on the point of your interaction with Ms. Nhansi and your receipt of the suspension letter.
Correct.
And then at paragraph 145 on page 27, you talk about your engagements with the media, because that was a concern, as I have it from your evidence, that Ms. Nhansi had raised the previous day when she was calling you about a national treasury. Apologies, the same day, because that was the 5th of July still. Recount for us, please, if you will, what is contained at 145, which, as I understand it, is just a summary of your engagements with the media.
Thank you, Chair. So after receiving my suspension letter, that was probably 5 minutes past 4, I'd gone back to my office, I'd taken my handbag and walked out. I'd left everything there, even my jacket, and had left. And because, again, having had my car in for a service, I needed a lift back to the place where I'd left my car, and I went again to my colleague, Lindsay, asking her, is it possible if she could get me to the place where my car was being serviced. And then I showed her the suspension letter and told her about it. But as we got into the car, by then it was almost 4:30, my phone rang. It was a number that I could not identify. The person identified themselves as Sabelo Skitty, saying that they are a journalist from the Sunday Times and they would like to chat to me. And I said, why? And he said, well, we've just heard that your job is in jeopardy, and can we please chat? And I just said to him, I'm sorry, I cannot talk to you, and I switched the phone off.
Thank you. And then in the chronology, as I have it, the next thing that happened on the 7th of July is that a letter was sent to SAA by Weber Wenzel attorneys. Who were they and why were they involved at this stage?
Okay, so from my having met with Outa on the 1st and subsequently on the day that I was suspended, the 5th, I contacted Outa when I got home that evening, And we arranged to meet again the following day, the 6th, and then on the 7th, they in fact met on the 6th, and they asked me then to meet with their attorneys called Weber Wenzel. I met with those attorneys. I actually went to the offices in Sandton and gave them the whole background of what's transpired since my first concerns, which started in December with the original board resolution. And they, with the BNP, they felt that they could stop this. So they wrote a letter of demand to SAA to stop the transaction going forward with BNP, and they sent that on the 7th of July.
If we could go to that letter, you'll find it at page 548 under tab 58. Thank you. You'll see is that the letter that you were referring to?
Yes.
I'd like to
Chair.
just advance to the demand that was made at the conclusion of the letter. You'll find that on page 552. As I read what precedes this in the letter, it's really a summary of, in essence, all the evidence you've given to us over the last 2 days, in summary fashion, talking about where the concerns lay in the whole process of procurement and engagement of BNP. And then in paragraph 11 on page 552 are the requested undertakings that were sought from SAA. Can you take us through those 2 undertakings?
Thank you, Chair. I will do so. So it states to suspend the performance of its payment obligations under any contract arising from the transaction advisor tender and the funding services decision. And number 2, to suspend the conclusion of any contracts arising from the transaction advisor tender and the funding services decision pending a lawful and a competitive procurement process for the relevant services. Thank you, Chair.
And then as I read 12, they requested an undertaking in writing by the authorized official by close of business 13 July, failing which they indicated they would launch appropriate proceedings in the High Court. Do you know whether those proceedings were launched?
Yes, they were launched because SA did not come back to them, to Outa or to Weber Wenzel directly on the first part. And so I had to work with Weber Wenzel again so that we could put documents through the High Court to interdict. Thank you, Chair.
Thank you.
And the contents of that letter, to the extent that they set out the history, Weber Wenzel got that history from you.
Yes, I worked with Weber Wenzel, the same information
Yeah.
that I've presented here, and the
Yes.
same information I
You
gave
gave
to
to
National
them.
Treasury.
Yeah.
The only addition was the BNP files.
Okay.
Thank you.
Thank you, Ms. Stimpel. The next document I'd like to take you to, which you referred to at paragraph 146 of your affidavit on page 27, you'll find under tab 62 at page 573. Now, Ms. Stimpel, I'm conscious of the fact that this document is dated the 8th of July 2016. As I have your evidence, you are no longer at SAA at this time, is that right?
That's correct, Chair.
So can I take it that this is not a document you saw then?
No, I did not see it then.
Chair, I'd like to just focus on this for a moment because it becomes relevant to later evidence, and it also will enable me just to explain one aspect of the files of Ms. Stimpel's evidence. Ms. Stimpel, what is this letter? Because you have subsequently seen it, haven't you?
I have, through your the Zonda investigators' offices, yes.
So
Thank you.
it appears to be a letter from BNP Director Mr. Mahlangu to South African Airways, is that correct?
That's correct.
And what is it dealing with?
Okay, it's dealing with regarding its FSB license, and it says there that they'd like to clarify the issue of the FSB license. BNP Capital received a letter from the FSB dated 12th of May 2016 indicating its intention to temporarily suspend BNP's license for a period of 3 months based on the reason that according to the FAIS Act Section 10, the key individual failed to successfully complete the first level regulatory examinations applicable to the categories and subcategories for which they are authorized to approve.
Or approved.
Or approved.
Thank you. Let's just pause there for a moment. When we looked at the RFP that went out for transaction advisor services, you'll recall the critical criteria there included an FSP license. Is that correct?
That's correct.
And BNP won that bid, did it not?
They won that bid.
And as this letter reads, it seems to be informing SAA on the 8th of July 2016 that earlier in May, and Chair, earlier than the date on which they were awarded the extension of scope for the sourcing of funds, they had received correspondence from the FSB indicating its intentions temporarily to suspend BNP's license. Is that as you read the letter?
That's how I understand it, Chair. Correct.
Chair, just to give you a bit of background, what the investigation has done is engaged with the FSB, well, as it then was, it is now the Financial Service Conduct Authority, in order to obtain their records in relation to the BNP license. That response to the request for information that was sent to the FSCA is the next tab in this file. It begins at page 578. But because of its relevance and significance to evidence that you will hear in due course, this was then followed up with a request for an affidavit from Ms. De Silva, who is the author of this initial letter. And that has subsequently been provided to the Commission. It will be found in File C of Ms. Stimpel's documents. I don't intend to deal with it further at this point, but that's just to frame it in terms of where we find it and why it's relevant. Okay. The only point I will make at this stage, and which you pick up at paragraph 147, Ms. Stimpel, is that the response that was received from the FSCA, including all the contemporaneous documents at the time, as I have it from paragraph 147 of your affidavit, indicates that contrary to what is said in the letter from BNP Capital on the 8th of July 2016, it was not the case that on the 12th of May their license was indicated as there being an intention to temporarily suspend the license. The FSB documents, as we have them, actually include a suspension of the license on the 12th of May. Is that your understanding of the documents?
Correct. That's my understanding.
Thank you.
Thank you.
I'd then like to move to page 28 of your affidavit, because you indicated in your evidence that the letter of demand went out on the 7th of July. The deadline for an undertaking was the 13th. I understood you to say that there was no undertaking given. Is that correct?
Correct, yes.
And then urgent proceedings were launched. Do you recall when that was?
Yes, after the 13th, I think there's still a couple of days waited, and then I worked together with Weber Wenzel for the documents to be submitted at the High Court, and we were there on the 21st of July to have all the signatures done, and then Commission of Oath signed, and then we had to submit it at the High Court before, I think it was before midday. So it was submitted, and SA did receive it on the 21st through their offices. Thank you, Chair.
And you detail at paragraph 151 on page 28 what happened on the 21st of July from SAA's perspective. Let me just get clarity. Did SAA ever respond directly to Outa or Weber Wenzel about their position in relation to the urgent application?
They did. I'm not aware if they did. That
Thank
I'm
you.
not aware of. What I am aware of is that in a press conference, they indicated that they have stopped the transaction then.
Thank you. So I'd
Yes.
like to take us to the media statement that was released on that day by SAA. You'll find that under tab 68 at page 833. There are a few features of this statement that I'd like to traverse with you. The first of those is under the first paragraph. It indicates that it's a statement of the 21st of July, 2016. And as I read it, it records South African Airways has taken a decision to terminate the services of BNP Capital as a financial services provider to the airline. The effect of this decision means SAA has terminated both its appointment of BNP Capital as transaction advisor and the appointment to source funds on behalf of the airline. The decision was communicated to BNP Capital yesterday. Do you see that?
Correct. Thank you.
And then if we go to paragraph 2, one of the aspects of the statement that is of interest, I submit, is at the bottom of paragraph 2. Chair, you'll recall yesterday when we were looking at the first appointment letter of BNP Capital as transaction advisor, we were querying the date of that letter, which was 20 March, because that was 2 days after the bids closed and before any processes had been embarked upon within SAA. This statement again records the award as having been made on the 20th of March, 2016. You'll find that at the end of of paragraph 2, where it is recorded the appointment of BNP Capital as transaction advisor was ostensibly in accordance with prescribed procurement processes, and the award was made on 20 March 2016. Do you see that?
Yes, I can see that. And thank you, Chair.
We will seek to clarify that with Mr. Mhlangu when he comes. But again, there seems to be at least an understanding from SAA's part that that decision was taken on the 20th of March. And then paragraph 3 deals with the attempts to source funds and what had happened in relation to the endeavors with a previous potential funder. Do you see that, Ms. Stimpel?
Yes, I do. Thank you.
What do you understand that potential lender to have been that was identified in that paragraph?
I identify that as FTC.
Right, and it concludes with the withdrawal was communicated by the potential lender to SAA in April 2016. Do you see that?
Correct, yes.
So as I understand this paragraph, and correct me if you take a different view, there's an effort here to explain the background to the sourcing of funds and why it ended up with BNP. And what's being communicated here is that there was a withdrawal from a previous potential funder in about April 2016. Is that your understanding of the paragraph?
That's my understanding, Chair.
Again, Chair, that may be significant because it suggests an interaction with FDC if they are the potential lender until at least 2016. And then it goes on to give further background to the due diligence that they thereafter conducted, their concerns around the FSB license, and ultimately, as I have it, the decision to terminate. They also deal with you, or at least their interactions with you in paragraph 9. Can you tell us what they record there?
Thank you, Chair. Before I go on to the interactions with me, is that they mentioned the due diligence, and we came across it in also previous correspondence to National Treasury, where it makes reference that a due diligence was done. But for the Treasury team at SAA, we've had no sight of that if there was any due diligence done. So I'd just like that to be noted. Thank you. Okay, so to go on to the point regarding myself, they've obviously stated here that I've been placed on suspension and that I've been suspended for misconduct, that I've acted in contravention of SAA's Code of Conduct, and that the decision to suspend me has nothing to do with the media reports suggesting that I had allegedly objected to SAA's decision to tender to the award of BNP Capital.
Well, what is your response to that statement?
My view is still that it's incorrect, that I've been placing my concerns in many ways, whether it was via an SMS, a WhatsApp, an email, via telephone calls, via physically having meetings. I've stated my objections. I've listed the issues I had around the whole process leading up to the point of BNP sourcing, becoming the sourcer now of funds. And and I had already stated I will take this further. So for SA to say that it was based on misconduct, I find is incorrect. The other thing is also that I have gone to the media regarding leaking out information is also incorrect, because I have not done that. Thank you.
Although they say you were suspended for misconduct, they don't seem to say what the allegations of misconduct against you were, or what the allegation was.
Exactly, Chair. I only received that the end of July.
Yeah.
Then I had a list of what my misconduct was. And
Yes, but if the alleged misconduct was about the document relating to BNP, then maybe they didn't want to really talk about that, because they seemed to want to distance your suspension from this issue of BNP.
Exactly, and agreed, Chair.
But it had everything to do with BNP.
It had everything to do with BNP, sir.
And if we could, Ms. Stimpel, then go to that notification of charges that you received at the end of July. You'll find that at page 837. Ms. Stimpel, you'll see there, was this the first time that the charges against you were made known to you?
Yes, the day I received them. There was no prior discussion on it. I received it as is here, and I had to sign it. I was called in and told to be in the office at 3, collect it, sign it, and leave.
And who did you meet with when you collected it?
Again, I met with Ms. Nahansi and then the acting General Manager of HR.
Thank you. And if we could go to paragraph 2 on page 837, because that, as I have it, records the 4 grounds on which you are alleged to have misconducted yourself. I'll just read through them, and then I'd like your overarching comment in relation to those charges. The first is unauthorized possession and removal of company documents. The second is insolence. The third is breach of substantive provisions of the contract of employment, including the confidentiality undertaking. And the fourth is breach of SAA's anonymous reporting policy. Let's just deal with each of them. Unauthorized possession and removal of company documents. What is your response to that?
I've taken the BNP documents. Being part of Treasury, sourcing funds being one of my main responsibility for SAA, I need to know who I'm working with. So I did not see it as unauthorized, and I did not see it as confidential. It's something that I needed to, just confidential for me not to pass on to others, but to do my work, I needed to know it. The fact that SA has taken BNP from transaction advisor to become the source of funds, I needed to know who the company was. So I felt I needed to know their profile, their capacity, and their capability. Thank you, Chair.
And the charge of insolence?
The insolence relates to a WhatsApp message, which I had sent to a colleague who was off sick at the time, and the date is even on the WhatsApp, which was the public holiday, 16th of June. I was at home with a bit of a flu, and I hadn't seen my colleague who had undergone an operation, and I wanted to know how she was. So I sent a message checking on her. Are you well? How's your recovery doing? And then I updated her, because she was an SAA employee, on what was happening currently at SAA.
Was this before your suspension?
Before my suspension. So this goes back to June. So I was surprised, very surprised, that this came in as a point of insolence for, as a charge against my misconduct.
And how much earlier compared to the incident that gave rise to your suspension?
My suspension happened on the 5th
Of July?
of July, and
This was sometime in June.
and it was the 16th of June, the public holiday.
But before you went on suspension, nobody had made an issue of it.
No, not at all. This only came up on the date I received it, which was the 27th of July.
Okay.
Ms. Stimpel, you'll forgive me, but I still don't understand why the WhatsApp interaction on the 16th of June is evidence of insolence. Can you just help me with that?
I think I can give you some background, because the lady that I had dealt with, which is Bożena Kowalski, she also worked in the procurement department, and we were, besides working colleagues, we were also friends. And I think she was approached, and they want to know, has Cynthia been in contact with you? Because when I went into the office to take the BNP documents, she sits right at the end. She was there, and I greeted her. I didn't speak to her at all. And I just said to her, I'm taking documents. She didn't know what I was taking. And so they obviously would have asked her, was Cynthia in the office? And she would have said yes. And then, is Cynthia in communication? I don't know if she was threatened, because for them to have seen that WhatsApp message meant that they had to go through a phone. So whether she had to hand it in and was coerced to give it in, or threatened, I have no idea. We've not spoken since, so I have no idea. I was just surprised that in that WhatsApp message, I think we have a copy of it.
Maybe before you go there,
Yeah.
I think Ms. Hofmeyer's focus is to see if you can tell her or tell me anything that suggests that there was insolence, that there could be a charge based on that WhatsApp for insolence.
Thank you. So it's based in...
Whether you understood where the connection is between your WhatsApp message and the charge of insolence. What was insolent about your sending that message, in other words?
Thank you, Chair. I'm sorry I wasn't more clear. In the message, I gave a background of what was happening at SAA, and then I also stated that our board continues its unethical behavior. That was my sentence.
Yeah, but I guess the question would still remain. Do you understand what's insolent about that? You may have said something that the board might not like, and other people in management might not have liked, but did you understand what was insolent about that?
Not that I could. In there, I spoke about, at that time, Mr. Nico Bezuidenhout had just resigned and left to go to FastJet. I listed that. It was all in the media. It was nothing that was not in the media. I also stated that the board had said that they always funded Mango, and then they withdrew their statement afterwards, and then I ended saying, and our board continues with its unethical behavior. Thank you, Chair.
Thank you, Ms. Stimpel. The breach of substantive provisions of the contract of employment, including confidentiality undertaking, what is your response to that?
I had no idea what I did there. Breach of substantive provisions. As far as I know, that I've conducted myself in the utmost integrity and honesty while I worked at SAA, so I was not sure what they were charging me against there. In the detail later, they bring out that was going to the media. Yeah, thank you.
And just help me also on number 4, the breach of SAA's anonymous reporting policy. What did you understand that charge to be?
That charge was that I didn't go through the whistleblowing process within SAA. So they have, we have our own whistleblowing where you could go through either through phone call or email for whistleblowing. And so they're saying it was a breach that I didn't use that method.
But you are
of
not
whistleblowing.
obliged to use it, were you?
No, you're not obliged.
It's something that's available to you to use if you want to use.
That's correct, Chair.
If you choose to go to the police, you go to the police.
Correct? Yes.
So why do they charge you with that kind of thing?
Thank you, Chair.
Ms. Stimpel, at the bottom of page 28, paragraph 155, you indicate that you initially decided to challenge the suspension, but you go on to explain why you didn't follow through with that process. Will you please explain to the chair what was going on and why you changed your decision to challenge the suspension?
Well, at the time, I was still working with, because when I received, I was suspended, and at that point in time, I was really at a loss, because I didn't know what my next action would be, and how do I approach the CCMA. I've never been in this type of situation before, but during those days, following from the 5th to receiving the final charges, was that I had been working with Weber Wenzel regarding trying to stop the BNP transaction. So up to the 21st, I was engaged constantly. We were because it meant reviewing the documents, going, seeking evidence, making sure that everything was 100% before they took it to court. So on the 21st, once that was done, come the 25th, I get noted that I must come and collect this, and the 27th, I went in to pick it up, and then they said there must be a hearing. When I went back to Outa to ask how do I approach, in fact, I went to Weber Wenzel, they said we need to get you a labor lawyer, and then we need to see how to now set up a CCMA date. And SAA had said that they would have a hearing, which we did attend on this date, which they had asked us to attend, but SAA was not ready for the hearing at the time. Thank you.
And then you go on at page 29 to detail, it's the conclusion of the preceding paragraph 155. You talk about continued postponements and delays that happened in the case. So when does that period of postponement take you to?
So the first, the disciplinary hearing should have happened in August, which I had appeared there. I did get a labor lawyer from Weber Wenzel. They were very kind to offer me a labor lawyer at the time. And we, SA was not ready. There was no one there. We waited, and eventually they moved it and said, we will set another date. My legal representative...
Was that for what is called conciliation, if you got to understand those concepts?
It was initially for the disciplinary hearing, sir.
Oh, that was still the disciplinary hearing.
The disciplinary hearing at the offices, and they were not available, SAA team. And then subsequent to that, my lawyer indicated that we should try and move directly to CCMA rather than wait for a disciplinary hearing. And that meant that we had to take my case to the labor court, which we did. And we then appeared at the labor court on the 22nd of August, which we had a full court hearing. SAA did have their representative there, as well as I did on my side. And the court ruled that we could take my case to the CCMA. We then, every time thereafter, dates were set for the CCMA hearing, and every time we came to the CCMA, it was moved or postponed by SAA. And this happened August, we met in August at the Labor Court. September it was moved to October, to November. There was nothing in December, and then in January it was moved to February. February was moved to March. And my lawyer then advised me, it is best just to settle. This will continue for another year, and you cannot continue with your life. You need to start getting continue with what you need to do and focus. And he recommended, at the time I did not want to, I wanted to go on with my case, and he recommended to get peace of mind, settle, let's approach SAA and see if they would settle. And I discussed with my family and they agreed, and so I went with his recommendation, Chair.
Ms. Stimpel, one of the aspects of the version of Ms. Nhansi, who will be giving evidence in due course, is she questions your decision to settle. She indicates that it's evidence of a lack of conviction on your part in the merits of your case, challenging these charges. What is your response to that?
I would say in contrary to that, because I really wanted to continue with my case. I definitely saw merit in it, and the main thing that my lawyer recommended at the time was, he said, how many months have passed? It's already been since July. It is now already into March. You need to get on with your life. And that's when I just made the decision, yes, I'll go with his recommendation. And so, yes, we did agree to settle. It had nothing to do with that there was no merit in my case at all.
At a certain stage, you were waiting for a disciplinary hearing at SAA. From what you have said, it looks like that never said. Did it ever sit?
It never did, sir.
And then you decided with your lawyer to go to the CCMA.
Correct.
I suspect that maybe that may have been what is called con-up or something like that.
Yes.
Is that what it
Conciliation
was
and
about?
arbitration,
Yes.
correct, Chair.
So while you were waiting, you were still on suspension, you were still being paid?
Correct, Chair.
Yes.
Yes.
Yes. So it's not like you were not being paid for the 7-8 months or whatever. You were being paid,
Yes, I was still being paid.
but the hearing was just not taking place.
The disciplinary hearing did not take place at all, sir.
And the con-up wasn't taking place itself. It got postponed all the time.
Correct. We were always prepared. I always sat 3 days working with my lawyer before the dates. When the dates came, we were sitting ready. They would bring in their lawyers, there'd be some discussion, and then there'd be a postponement.
But I would have thought that because that was now under the auspices of the CCMA, they wouldn't have got, the matter wouldn't have been postponed unless it was by agreement between the lawyers on both sides and the CCMA, or the CCMA ruled that there were good grounds for a postponement with your lawyer opposing any request for postponement from the CCMA side. Do you know whether each time it happened it was one of those two situations?
Correct, Chair. They were both always in agreement. There was always a discussion. The two lawyers would get together, discuss. My lawyer would come back and say, this is one of the reasons we cannot continue, whatever, and we're going to motivate for a postponement. So that's what happened. So the lawyers, yes, did get together. They did come up with an agreement. For whatever reason, the one time the lawyers were there, we were waiting for the SAA representatives. They didn't come. And then when there were SAA representatives, they weren't the senior representatives. They sent the HR person, and they sent a risk person to represent SA, but it wasn't Ms. Nhansi. It wasn't Mr. Twane. And my lawyer said he was not prepared to continue if the executives of SAA were not present. So there's always postponement.
Well, we're not here about unfair suspensions and unfair dismissals, but of course, one of the things which have been said by some witnesses here is that in regard to corruption in government departments and entities and parastatals. What was happening was that you would find that in each of the entities that are affected, there would be people who would insist on the right things being done, who would be opposed to wrong things being done. And there would be people who would be pursuing wrong things, breach of rules of procurement procedures, pursuing corrupt agendas, and that those who were standing for the right thing were opposed to these corruptive agendas, were seen as stumbling blocks, and that sometimes, maybe very often, all kinds of charges would be brought against them. They would be suspended on no sound grounds. Charges would be brought against them that have no basis, just to make life difficult for them and, if possible, to get rid of them. And so that's part of the reason why I'm looking at the issue of whether the postponements were by agreement, because that might give a certain context then in a situation where it's like a disparate hearing, where maybe from your side you could argue whatever you argue and SAA just postponed. There was a third party involved here, the CCMA, and so on. But so that's the reason why I'm looking at it. But it still remains important to look at, were there proper basis for the charges against you while you were suspended, and so on and so on. Okay.
Thank you, Chair. I still feel there wasn't proper basis.
Yeah, so
It's
we
my
might not
personal
go
view.
into finer details, but still it's important to try and have a look at whether there were proper basis for suspensions and so on, because if there were proper basis, the case might not fit into what has been suggested, but if there were no proper basis, it might fit into that. Thank you.
Thank you, Chair. Just two follow-up questions from that, Ms. Stimpel. Do you regard yourself as being in the category that the Chair has described, of persons who were suspended on meritless charges because they stood up to what they regarded as being irregular and potentially corrupt?
Yes, I do.
And a second follow-up, in the course of your evidence, I've noticed at least two references to other employees of SAA who were suspended. You made reference to Mr. Bosk, because when you went to engage about what you should do to whistleblow, as I have it, you were cautioned that you would just be placed on suspension as he was. And then I recall you referencing Ms. Mshe. Chair, Ms. Mshe will be giving evidence in this session, so we will hear from her firsthand, but she was also on suspension, as I have it, when she called you and you asked her about the whistleblowing and she suggested the public protector. Could you give us the benefit of your insight as to that as a feature of the way in which management was being dealt with and employees were being dealt with within SAA?
What was transpiring around SAA at the time, if anyone challenged what was being directed from board at the time or certain senior executives that have been placed in positions at the time, if you challenged anything that you knew was not correct, that you were immediately suspended your charges were not given at the time, and only afterwards charges were made up, and then you were given your charges. So it was a method. At the time I was suspended, there were at least 4 other people suspended. That's how many during my time. And it seemed to have been a pattern that you were given documents to sign, so your signature's on it. You weren't part of, like I was also given, and if you didn't question it and challenge it, the documents would be approved. But if you challenged it, they would find a way of getting you suspended. If you were tasked to do something, some people were tasked to get rid of certain people in their departments or find issues against them and suspend them. And if you challenged that, then they would, I won't say they, but senior management would try and find some issues against you to get you suspended. So it seemed to have been a pattern that was going around in those couple of months. Thank you, Chair.
Well,
Clear enough.
while it may have been so, but it's quite important that when you make a statement like that, you are alive to the fact that your evidence could be challenged, and there could be an attempt to say, let's look at each one of those, let's test what you are saying, and then there would be an attempt to show that there were proper bases for at least maybe some of the suspensions and so on. So just be careful when you say, it seems like there was a pattern. But if you have got facts on which you base that, that's fine. I'm just saying be careful,
Yeah.
so that you don't say there was a pattern if you don't have facts to back that up with.
Thank
But
you,
if
Chair.
if you do have facts, by all means, you have to state that.
Yeah.
Okay.
And I can only then speak on the 2 that I do know, Mr. Sylvain Bosque
Yes.
and Ms. Julie Mshe, which I have mentioned previously.
Yes.
Thank you,
Those
Chair.
those
Noted.
ones you say
Yes.
there were no proper grounds.
Correct.
Okay.
Thank you.
And the suspension of Dr. Dawa, do you have any knowledge of that? Chair, these are witnesses who will be coming in due course. We
That's fine.
take note of the
Yes.
need for specificity
Yes,
in relation
yes.
to these types of
Yes.
themes that seem to be emerging.
Yes,
So
yes.
you will be hearing evidence from at least Ms. Mshe and
Yes.
Dr. Dawa in this session, and potentially Mr. Bosque in the second session.
That's fine.
But just in terms of your knowledge of Dr. Dawa's circumstances, were you aware of his suspension?
I was aware only because a notification gets sent out to all the staff when anyone leaves the company, especially if they're senior, and if they are suspended. So we as staff members got a notification that Mr. Dawa has been suspended from SAA. There was they also had serious, it was listed in the email that it was also under some misconduct, and nothing further stated than that. So yes, I was aware that Mr. Dawa was suspended. Thank you.
Ms. Stimpel, I'd then like to take you to the last page of your affidavit, page 29. And paragraph 157, you talk about the terms on which you settled with SAA. And you talk about what pecuniary benefits you gave up as a consequence of that settlement. Can you tell us what those were?
So basically, I was 59 at the time, and that was one of the reasons my lawyer said that should you win your case and go back, they will find something else and will place you in a position where you're unhappy, and hence, we came to the position of accepting settlement. With SAA, my settlement was based basically on, initially it was supposed to be around 8 months, but because I already got paid for March and April, they took that away, so it turned out to be a 6-month settlement and of my salary. And I was, and that's all I received together with my normal pension. SAA does offer travel benefits. I did not receive any of the travel benefits. And yeah, and that was basically it.
Did your settlement, was your settlement formulated in such a way that your employment with SAA would continue for 6 months and your 60th birthday would fall within that, so that you would effectively take retirement without having left before? Is that how it was structured?
Yes, so because I was 59 turning 60, so we worked on sort of early retirement benefits. But with the early retirement, I should have got travel benefits or other, but I got none of those. So yes, they factored in the 6 month salary that I would have got turning 60. Yes, and then that's what I got paid. Correct, sir.
Okay.
And Ms. Stimpel, the last paragraph of your affidavit refers to a disciplinary hearing that took place in 2018 against Mr. Zwane and Ms. Nhansi. What is your knowledge of that process?
Okay, thank you. I just want to make a record change that this date could be incorrect, and maybe you can contact
Advocate Kasim.
yeah, and just get the correct dates there, please.
That
But
20
yes,
April 2018.
correct, yes. It was in 2018, but I may have the dates wrong, and I meant to check it up, so my apologies. But yes, I was called in by CDH at the time, which is Cliff Decker Hoffmeyer attorneys, who had asked me if I could please come and be a witness and testify on behalf of SAA this time to witness against Ms. Nhansi and Mr. Twane. The company had placed both of them on suspension after some investigation, and they were doing their disciplinary hearing. And because one of the issues that came up was on the BNP case, and they asked me if I could come and testify on the BNP case, which I agreed to, and which I did. Thank you.
Was your evidence in relation to Ms. Hansi include what you had been suspended for in relation to taking the document that she was unhappy you had taken, and your intention to or taking it to National Treasury, or intending to take it to National Treasury, or going to attend a meeting there, but them thinking you are going to disclose it to National Treasury? Did it include that?
It included everything that I've had here to date, sir. So similar process, I had to go through the process of, from the start, covering the whole process from the first board resolution up to BNP being appointed, how it was appointed, etc., up to the point of my suspension, the reasons why I was suspended, together with the documents that I took, together with the charges that were related in my suspension. Thank you, Chair.
At the time of that disciplinary hearing, had there been a change of the board of SAA, or was it still the board that was there when you were
It was a new
suspended?
board.
It was a new board.
It was a new board that were put in place, Chair, and based on some investigation, the board had placed, at the time, the two senior executives on suspension, and then asked and had an investigation, and then had the subsequent disciplinary hearing. Thank you.
Thank you, Chair. And just for the purposes of the record and future evidence, the findings of that disciplinary process are contained as the last annexure in Ms. Stimpel's bundle from page 841. And that is an aspect that Ms. Nhansi takes up in her statement and will do so in her evidence.
Thank you.
Ms. Stimpel, the last question from my side just relates to the criticism that is made of you in Ms. Nhansi's statement to the Commission, which we will deal with next week. She has numerous criticisms of your character and the manner in which you engaged with her, and I would like to give you an opportunity for the record to respond to that.
Are you going to read what you wrote?
I can.
I don't have it in front of me.
There are a series of allegations as to your bullying mode of engaging with her. There are allegations about, on one instance, you representing a racist attitude, and those are the aspects that I would like to have your comment on.
Thank you, Chair. I don't have it in front of me, that I just want to know which point it was, because it goes throughout the document. But I actually object to that. I recall in her writing, she says, I used to storm into our office and swear. It's actually not in my nature to swear. I think the word I use often is damn, if I have to go to a bad swearing word. And I was always highly respectful of Ms. Nhansi. I always made an appointment first before I could see her, and she had a secretary that wouldn't allow you to enter her office. So I found that very untruthful of her to state that in her statement. I have not done that. Also, there's the statement saying that I have told her she doesn't belong in that position because she only got it because of BEE. I would never have done that. And again, I say that is untrue. On the contrary, I always felt sorry for Ms. Nhansi. I saw her first as a mother.
Yeah, I think it says because of affirmative action.
Yes, yes, of affirmative action. And, but I always saw her first as a woman and as a mother, and I always respect that first in my colleagues. I see them first as that person who has to take care of others, who has to nurture others, and that's how I saw her first. And I even told my colleagues, I wonder why she's following this agenda and pushing the BNP, you know, and not listening to us and seeking advice from any of us around her. So yes, I disagree with all those. They're all untrue. Thank you.
Chair, there are no further questions from our side, subject to any further from you.
No, thank you. Thank you very much for coming to share your evidence with the Commission. You may be asked to come back at a later stage. I'm sure you will have no problem. But for now, you are excused.
Thank you, Chair.
Thank you.
Much appreciated.
Chair, the next witness, Mr. van der Merwe, is here. We're happy to start with him now, unless it's convenient to take an earlier break. We're in your hands.
No, I think we can start.
Certainly.
Do you want 5 minutes to?
Could we just arrange
Yes.
the table
Yes.
and have things ready? Thank you.
Okay. We'll, at 5 minutes,
5 minutes will be fine.
we'll adjourn for 5 minutes.
All rise.